We are here in the case of Becky Josie versus Phillip Josie. That's 29633. Each side will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you plan to reserve time, let me know when you begin your argument. I'll be keeping track of the time, and I'll do my best to try to keep you apprised of your time as it proceeds. The arguments are being visually and audibly recorded, and they will be posted online when this argument is completed. Do not use the names of any children, although I don't believe that's going to come up based upon the issues in this case. We have read your briefs in this case. We are ready to begin when you are. Mr. Donner, you are the appellant in this case, so we'll start the clock whenever you're ready to begin.
I'm ready, Your Honor. Thank you.
All right. Sure.
To please the court, I am John Donner. I represent Phillip Josie, who is a retired major from the United States Army. I would like to reserve 5 minutes of my time for rebuttal. Mr. Josie has served admirably for this country, rose up from the rank of lieutenant to major in the United States Army, then the U.S. Army Reserves. He has served 4 tours of duty in combat zones. Unfortunately for him, he was diagnosed as being 100% disabled due to PTSD and severe depression relating to his tours of duty. He did not have 20 years of service, and so he was not eligible for a regular full military retirement. When he came back stateside from his last tour of duty about just a little over 10 years ago, they put him with a wounded warrior battalion and gave him desk duty to serve time. He was going through further diagnoses at that time. In 2011 or 2012, he applied for disability benefits, which long-term disability benefits for military personnel are filed through the Veterans Administration. While that was pending, the divorce was pending. The divorce was pending from 2008 and was resolved 6 years later in 2014. Just prior to his being declared eligible for benefits, about a year or so prior to the divorce, there was a deal that Mr. Josie worked out with the U.S. Army. He was eligible and did receive temporary temporary disability classification, so he could receive a military pension. At the time they granted that to him, he had already applied for, and he was awaiting a determination by the Veterans Administration. All of this was known at the time of the trial. Just months after the trial.
Can I stop you for 1 minute there? Would it also have been known that if he received his disability, whatever portion, or I should say whatever amount he received would be offset from his pension? That wasn't a surprise, correct?
That would not have been a surprise. I was not the attorney for Mr. Josie at the time, but that would not have been a surprise. That has been in the federal law since the early 1980s. There's a case I cite in the brief of Mansell versus Mansell, which is a 1989 case that the U.S. Supreme Court ruled on this issue of the waiver and how this affects other division of property and spousal support.
And then what, am I to understand that that's the reason that that language, and I think you know what language I'm referring to, was put into the decree?
No, I don't think that's at all the reason that language was put into the decree. In the last 10 years or so, this really came up a lot in divorce cases with the Ohio Police and Fire Pension Fund. And the court discovered in the 2000s many members of that who had divided their pension in a divorce were later joining and opting to do the deferred retirement option plan, which everybody refers to as the DROP program. That's probably the most notable reason why Judge Dezzo would include this type of language in there. And it's very ambiguous. The language he put into the decree says, if necessary, the court may enforce other orders, including recharacterization of the benefits, if payable under another retirement system or a spousal support if applicable. So if you look at it in the context of DROP, the court can enforce other orders, including the recharacterization of the benefits, because now it's not a police and fireman retirement DOPO that is going, division of property order that will be put on. It will be a order concerning DROP. And there's other programs like that. But federal programs are federal programs, and they have a different set of laws. Why that wasn't specifically raised or done, I'm not sure. As I said, I was not at the trial. But that kind of ambiguity hasn't helped this situation at all. But Mr. Josie, just months, I think November of 2014, just months after the divorce, received notice from the Veterans Administration of two things. One is that he had been classified and approved as being 100% disabled. And the second is that he would receive commensurate Veterans Administration disability payment retroactive to August of 2014. He did receive that, and pursuant to 38 USC 5305, there's a mandatory waiver of dollar for dollar from any military retirement that he is receiving. The effect of this is his retirement went from over $4,500 a month. His military retirement went from over $4,500 a month to about $450 per month. On spousal support, it's interesting how the court handled this in the decree of divorce itself. And I'm not saying by any means that this is an attack on the order. I'm just by reference saying this is what the order said. I don't think this at all is an attack on that order. This is based on the interpretation later made by the trial court in post-decree matters, including last summer in a June 2019 order. But the court says a number of times, 15 months of support, spousal support, at which time spousal support terminates. And at least twice in the divorce decree, that's exactly what the court said. Spousal support will terminate. Why is it going to terminate it for 15 months? Well, he had already paid almost 6 years of spousal support under the temporary orders. So he's going to pay 86 months, which is just a little over a third of the length of the marriage, which is typical for a marriage of this term. That's what he has paid. Now, I know the appellee is going to argue that, well, there is no jurisdiction to even consider that again, but that the appeal time for those decisions has come and gone. A couple of appeals have been done. And let me explain a little bit about what happened. The magistrate had a remand hearing in early 2017 or maybe 2016, and Judge Cook ruled on the objections to the magistrate's decision on December 5th, 2017. Sua sponte, 3 weeks later, December 27th, she issues a nunc-pro-tunc entry. That nunc-pro-tunc entry remands the matter on 5 different areas for an evidentiary hearing before the magistrate. This court is clear on when there are remaining issues that are unresolved that relate to this. It is not a final appealable order. Those issues have to be resolved. The judge remanded a determination of what spousal support had been paid, a start date for spousal support, presumably the new spousal support, although it's unclear in that order, specific date, money has already been paid, required the CSEA to do an audit concerning overpayments, and it addressed what would happen with the overpayments, if there were any, and when the start date may be on I'll call it the new spousal support or the recharacterization of this retirement benefit.
Counsel, I guess this is maybe not fair to ask you, but is that truly a nunc-pro-tunc entry? I mean, nunc-pro-tunc is just to correct a clerical, ministerial matter, and it sounds like she really went to some substantive issues there. I don't know how that affects your appeal, or if it even does, but it doesn't really sound like that was nunc-pro-tunc.
I don't know if it's nunc-pro-tunc either. She did it within that 30-day time, and my client, pro se, Mr. Josie pro se, filed an appeal, I think on January 4th of 2018. The judge, let me just take a step backwards. When the remand hearing was finally held, and there was a stop and start of that remand hearing, and it was heard last May, I believe, and the magistrate's decision came out in early June. The magistrate once again ordered fresh the spousal support and quoted the language from the decree of divorce that the court had the jurisdiction to recharacterize the loss of retirement pay as because of this waiver as spousal support. But back in the first appeal, my client filed the appeal, and interestingly, and that was before this court in case 28919, on January 24th, 3 weeks after my client filed the appeal, the appellee, Becky Josie, through her counsel, files a motion to dismiss the case for lack of a final appealable order.
Counsel, hang on a second. I'm pausing because I was engrossed in what you were saying. I want to let you know you have like 3 minutes and 45 seconds left total.
Okay.
So you're free to keep on going, but I want you to know you're in your rebuttal time.
Okay, I'll stop at this point and I'll wait for rebuttal. Thank you.
Okay, sure. Mr. Chrislip, whenever you're ready.
Am I unmuted?
Yeah, we can hear you.
Okay. Thank you, Your Honor. Your Honor, Attorney Ken Chrislip on behalf of Becky Josie, who is the appellee in this matter. May it please the court and opposing counsel, John Donor. Your Honor, our brief lays out a number of what I would consider procedural issues here that relate primarily to jurisdiction. And I'm going to start with the first assignment of error that we raised. As counsel has pointed out, the judge, Dezo, in this case back in 2014, made very specific rulings on what would happen should this retirement go away. When the court is deciding marital issues and how to divide marital property as well as marital income, they take into consideration what would be equal. When Mr. Josie was finally determined to be 100% disabled, the court knew that that was going to significantly impact Miss Josie's receipt of monthly income. They were married back in 1986. This marriage was not an easy marriage for her. I have no disagreement with Mr. Donor's characterization that Mr. Josie has served our country and served our country well. But as we all know, there are some ramifications that come with that, consequences that come with that, that affect the home life. I can tell you that Miss Josie has been through quite a bit dealing with Mr. Josie. This was not an easy marriage for her. In fact, she still, to this day, has a protection order out against him because of his behavior. I say that just because these were issues were brought up during the court. And I do believe that Judge Dezo recognized that very shortly after this decision was going to be made, that there was going to be a change in what Miss Josie would be receiving for purposes of retirement income, which is why she put the language in there, if this is to be recharacterized, or spousal support, which would be another option to help make her whole, so that she would not be left out of not receiving the proper amount of monthly income that she would otherwise receive. All of that money goes directly into the pocket of Mr. Josie, and she's left with nothing. And I do not believe that that would be equitable, and I do believe that the court foresaw this. I would agree with Attorney Donor that the language is ambiguous. There was an opportunity for Mr. Josie to file an appeal on that 2014 divorce decree. He did not do so. So any objections or any problems that are present in the original decree needed to be addressed back in 2014 after this decision was made. But moving forward, Ms. Josie did file a motion pro se on her own, asking the court to recharacterize the money that Mr. Josie was getting through disability as spousal support. She filed this not to change what was already in the original decree, but to simply enforce what was already in the original decree. And we had a hearing on this. Before Mr. Donor was on the case, we had a hearing on this with his counsel at that time. The magistrate made a decision on that, and she upheld my client's motion. She essentially reinforced what was already ordered in the court, and she ordered that Mr. Josie is to pay spousal support. That decision was not properly appealed, and so now we move on. And we move on in that situation when Mr. Donor filed a motion to reconsider. The court denied that. That was a final appealable order. That was never appealed in an appropriate time frame. So we do have another hearing, and that hearing initially was specifically set to determine financial issues that relate to the legal issues that were already decided, meaning start date, if there was an overpayment, issues along those lines. The actual legal arguments that were being raised, or that were being raised by Attorney Donor, that are being raised now, have already been decided. They were decided back in December 27th of 2000 and I believe 17. I might be getting my dates wrong there. But those issues were decided. Yes, there was an appeal filed, and yes, we did file a motion saying it was not a final appealable order. However, this court did not rule on that. It was voluntarily dismissed by Mr. Josie. So now we go back to the issues here, where even if the court could decide these issues, even if there was jurisdiction for the court to decide these issues about whether or not recharacterization and spousal support could be done, there is Supreme Court case law that states that you cannot do that because the law changes. This is not a related case, meaning this case is not an extension of a previously filed case and now we're doing something subsequent. I did cite case law to that, and I believe that that case law is Doe v. Trumbull City Children's Services Board. And it clearly states that if we were to change every case that has new law that comes, we would always be in litigation. This case needs finalization. And I believe that at this point, this court no longer has jurisdiction to decide anything. And even if it did, based on new case law, I still think the court would lack jurisdiction to make any changes. There were a couple other, sure.
I'm sorry, can I ask you a question?
Sure.
Would an alternative method to deal with this be to reduce the wife's portion of husband's retirement to property division amount, a property division amount, and have it be paid through that way instead of through spouses?
Well, I think the problem with that, Your Honor, is that because disability is not considered marital property, I think the only way to handle this is to do spousal support, simply because she's not entitled to the disability income that he's receiving, which is why even in Howe, they even added, as more or less at the end of the case, they even indicated that if this situation were to occur, one remedy would be to remedy this through a spousal support order.
So was there a determination of a dollar figure made of wife's portion, her half of the 73% that was marital at the time of the final divorce decree? I'm just asking a curious question.
She was entitled to, Your Honor, I'd have to get to that. I think she was entitled to like 38% of what she was getting from the actual retirement. And it was a specific dollar amount because she was receiving a specific dollar amount. And what the court did was essentially change that into spousal support, so she was getting the exact same dollar amount that she would have otherwise been receiving.
Thank you.
You're welcome. And then there's just a couple of other issues. Your Honor, how much time do I have left?
7 minutes and 30 seconds.
I'm doing very well then. The other issues that I would like to touch on, one of the issues raised by Mr. Josie was that the court did not make a proper finding of change in circumstances. And I would say to that simply, when someone's income is cut almost entirely off from a divorce proceeding because of something that had happened, whether this was husband's devious plan or whether this is just what has to happen because he's in the military, that certainly acts as a change in circumstances when somebody loses a substantial amount of income that they were otherwise getting. So I would say that I think that there's certainly enough to justify a change in circumstances. There are other issues that were brought up in the appeal here that were not otherwise raised in any other prior objections. And I would believe that if you don't raise these in an earlier court, I don't believe this court would have jurisdiction to hear them now. And I'm trying to find through my notes here exactly what those issues were. I believe it was to modify the divorce decree without express consent of the parties. Well, that was never raised before. That was something new that was presented in Mr. Josie's brief. In conclusion, Your Honor, I believe what the court had intended to do back in 2014, because these issues were very well known to the judge, and I believe both parties were pro se during this trial. I don't think that either one of them had counsel at that time. But my reading of the decree and my discussion with my client that this issue was specifically addressed, and the judge had very detailed knowledge of what was going to be coming in the future, which I think is the exact reason why she put the language in there, is to protect Miss Josie in case he were to be declared 100% disabled. Now he receives 100% of his income tax-free, and his wife receives nothing. And the Supreme Court cases that were cited by Attorney Donor also provide in there that there is a remedy to this, and the remedy is making an order of spousal support to help keep the other party whole. Otherwise, this is not an equitable division of property and income and assets, and that's the whole spirit of going through a divorce and making sure that each party is made whole at the end. I don't have anything further, Your Honor.
All right, thank you. Mr. Donner, you have 3 minutes and 44 seconds.
Thank you. Concerning that last point that Mr. Chrislip made, that exception in Howell is very, very narrow. And I went to great detail in the brief to explain that nothing was done to characterize this as spousal support. It was just property division, let's call it spousal support. In Howell, they said, if the requirements are still there and the need is still there, and spousal support is still something the court is considering or something that's going on, the court can modify spousal support for that reason. There's an absolute prohibition about just changing the name of it and calling a property division spousal support. At the hearing, there was zero evidence. At the initial hearing before the magistrate, there's zero evidence on any change in circumstances and the need for spousal support or why it should continue. It is completely different and separate from the spousal support that was awarded during the divorce. The change in circumstances in the appellee's brief and what they referenced today, there's a two-part test, or only saying one part. It's a change, this is in the Mandelbaum case, which I say, it's a change in circumstances not contemplated at the time of the divorce. Certainly this was contemplated, everybody knew he was applying for disability. Judge Dezo had 24 years on the bench as a domestic relations judge, another 10 or 12 years on the bench as a referee before that. She has a lot of experience. She is a good drafter of her decisions. There is nothing in there that says if Mr. Josie gets his VA benefits approved and there's a reduction, then we will do this. She has a general phrase that she used in many of her decisions that does not apply in this case because federal law preempts it. The last thing I'll say is the law did not change with Howell as a clarification of the prior law of Mansell, which is also cited in the brief. That goes back to 1989, that you cannot divide this in this fashion. Thank you.
Judge, I have one question for Mr. Donor, and I just need clarification on the date, if you can, that husband was awarded his disability compensation for the PTSD and combat-related compensation. For some reason, I have that occurring prior to the courts granting the divorce. Is that true?
No, he was discharged November 19th, 2013. The divorce was in 2014, May 1st, no. It was November 12, 2014, after a May 1st, 2014 trial. And then he was determined in November 2014 that he is eligible, I'm sorry, October 25th, 2014, I think Mr. Chrislip disagrees. I think he put December 2014, but one of those dates, the VA awarded him disability benefits based on 100% disability, retroactive to August 2014. So
all
the
right,
trial is May.
Go ahead, I'm sorry.
Okay, the trial is May. The benefits begin, the retroactive date was August. The determination was made in October or December.
So the trial was actually in May.
Yes.
All right, thank you.
All right, gentlemen, thank you both for very good arguments. We'll take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and the website of the Supreme Court. Have a good day and stay safe.